didn't need the Zoom, so. I didn't need the Zoom.
All right. All right, then Mr. Chomley will need to wait for his plea. Anyone else ready?
You're not ready, if my client's up, I'll wait.
Who's your client?
Stephanie Navarro.
The plea, it's a plea.
All right, is the paperwork ready?
I just need to swear her into.
You can bring her in to be sworn in.
I left the door locked because everybody wants to come.
Oh, yeah, no, let's not do that because then it makes it very complicated. Who are you here for?
I have a case tomorrow. It's off docket. I have it's a first setting THC case. I'm talking to Melissa about it. I have a vacation letter in. I'm out of town.
What is the cause number?
The cause number is. Glasses on. Two 2025 CR 000172.
Is that 3 zeros?
Yes, ma'am. 3 zeros.
And is this Maris Gabriel,
Gabriel.
Maris Martinez?
Correct. Gabriel Martinez. Yes.
Norma, can you check? Was that case dismissed for PTD?
So we were sent over PTD and then we had some issues and now we're sent back. And Melissa's going to take a look at those issues.
It shows that a dismissal was filed.
Yeah.
Yeah,
December.
and it was re-indicted.
Ah, so it's been re-indicted?
Yes, ma'am. Effective date. No.
Yeah, they said that we had a violation of our pretrial diversion. So I was talking with Melissa today about some of those issues and she said, okay, let's look at it.
And where are you gonna be? You say you have a vacation letter?
I am going to be in New Orleans, Louisiana.
All right, and when
I'll
are
be
you back?
back on Tuesday.
All
My
right.
wife's birthday and she like,
Oh,
it's really cool.
Norma, if you can recall this for November 20th, is your client on bond?
He sure is.
Will you let your client know?
Sure will.
All right, thank you. You're excused.
You said November 20th. Yes. So I have a federal sentencing in the Austin Division of the Western District of Texas at 11. Yeah, well, 10:30 on that Thursday. Are Thursdays the days that we want?
Norma, recall this for December 1st.
Thank you, Judge.
Thank you.
I'll see you next time.
You too.
Off docket motion to set 20 to get a on-site line note.
Yeah.
Oh, he's in custody right now. Okay.
I'm not trying to do it.
I'll also do it tomorrow.
He's wearing a pink tie because I'm using.
Okay. Okay.
Norma, you have that cause number for Gabriel Martinez?
Yes, ma'am.
All right, thank you.
Uh,
Who else has been sworn in?
actually, next one.
Monday, Tuesday.
Hi.
I've been signed in.
What have you been charged with? Because I'm not going to follow that agreement.
Judge, what are you doing on PTV applications? We turned it in over lunch
Oh, where's your client?
in the hall.
Bring him in.
Thursday works.
Judge, I have an off docket matter related to next week. Almost said come at 1:30.
Thank you.
And we have a moment.
I'm signed in already.
All right, I will get to you in a moment.
Do I need to bring copies of those? Hold on.
Yeah, can I hold
And
on?
there is a emotional support animal for the thing on your docket.
Mhm.
I signed in this morning, but we didn't. That was also November 11th of every year.
All right, Norma, I need a 30-day reset for PTD. Mr. Perales, come forward. What date for PTD?
I can do the 15th.
All right, you'll be back here on December 15th. Once you sign the reset form, you're excused.
Thank you.
All right, thank
Thank you,
you.
Judge.
You too.
Wednesday.
We have on.
Maybe.
Yes, I messaged the quick one. All right.
All right, Mayor Quinn.
She may be out while she was here this morning. The door was locked when I got here.
Have her come in,
Okay. The door's still locked. We don't want everybody.
but just her.
Do you have a link up there? Signing it? Because she's gonna call us a case. Thank you.
Good now afternoon is Cinco.
Yes. So she's scheduled for trial today.
She is.
All right, so yes.
I have an issue and it's a short issue. If I could be recalled next week, I have a mandatory board meeting that I sit on a board in Waco. That's tomorrow and Friday. And I thought I had put in a vacation letter, but I did not. And I do not want to miss it because it's only quarterly. I'm happy to come do it Monday. And the state also was going to call the previous prosecutor to see if what I told them was what was true. So, I mean, they didn't have an objection to waiting till next week. I don't know what the court's calendar is next week.
Norma,
Yes, ma'am.
recall this for jury trial on the 17th.
Okay.
It's Mayor Quinn.
Yes, ma'am.
All right, we will have you up on the 17th.
Perfect. We'll be here Monday. Thank you, Judge.
All right, once she signs the reset form, she's excused.
Okay.
Thank you. Dwight Chumley. All right, Adolph Mendoza, are you all ready?
Yes, Your Honor.
Meredith,
Have your client, if you'll have your client come in.
Well, you said, they've had like, what, 3 weeks with the witnesses. I want that.
Hello. Hi, so he's scheduled for jury trial.
Yes, Your Honor.
We'll see if this will continue, but you're on call.
Yes, Your Honor. No,
All right, Ms. Ferguson Mendoza is on call.
and should something foreseeably go to trial ahead of Mr. Mendoza's, I guess we can approach the coordinator or speak with the coordinator about a reset date?
Well, what I'll do is I'll have you all come back on the 13th. Ms. Ferguson will let your client know whether or not he can appear by Zoom or in person. If
Okay,
we're in jury trial, it'll be by Zoom, and then you can confer with the state on a new jury trial date.
sounds good, Judge. Thank you.
All right, thank you. Norma, if you'll give him a reset. Can someone, can one of the attorneys check and see if Dwight Chumley is outside, please?
You got lost?
Yeah.
I can send him a text. Adolph Mendoza?
Oh, yeah, I get it. I'll get it tomorrow.
Okay.
You're welcome.
I'll be right back.
And Norma,
Yes, ma'am.
recall Morales. Do a reset form for him on the 13th. He's on page 2.
Yeah.
Negative results.
All right, thank you.
Yeah.
Luis Morales.
He's outside.
Oh, that's your client?
Yes, ma'am.
Where are we on your case?
So I conferred with her. I gave her a thumb drive for 2 large videos that I didn't have. And they're uploading that right now for me, Judge, and she's conveyed to me a new offer, kind of mulling that offer over right now. That's where we're at.
Norma, recall this for the 18th.
Thank you, Judge.
You're welcome.
And I was here, I checked in with the court. I just wanted to know I didn't just pop in at 1:30 today.
Okay.
For discovery.
Give it a poke, Dwight.
No, that's, they need to work off docket for a plea if they're gonna complete a plea.
Thank you, Judge.
Miss
Thank you.
Navarro's here. Stephanie Navarro.
Good morning. Well, you're what, they all got out of your hurry.
I don't mind having to go here without one morning.
And Norma, that's gonna be a plea deadline date.
They're not cherry. But the
Jamar Clark.
Uh-huh.
Court is calling 2024 CR 008195-02. State versus Jamar Clark. Can I have parties announced for the record?
Dwight Chumley for the defendant now.
And are you Mr. Clark?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Clark, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Proceed on the Western offense at disorderly conduct of prosecution.
Any objection?
No, Your Honor.
Are there any applications?
Yes.
Yes. Ooh. Maybe not. Hold on.
Thank you. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense, or at least the state is proceeding on the offense of disorderly conduct as a Class B misdemeanor. Range of punishment is anywhere from 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did you understand it and sign it? Did you understand if the court were to grant an application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to a $2,000 fine and up to 180 days in the Bexar County Jail? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Clark, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you can be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. There are no applications for deferred.
No, just straight probation.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 6 months in the Bexar County Jail. There's a $500 fine. State recommends community supervision. They're proceeding on the lesser included offense of disorderly conduct. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of a year. There be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
No objection, Your Honor.
And state, have you had a chance to speak with the complainant? All right, thank you. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Clark's been a perfect client. He's been at court many, many times. He's never missed a time. He's never been late. He always shows up well dressed. He's been very helpful in me helping defend him. We spent a lot of time looking at the facts. We negotiated this deal in good faith at the DA's office, and he recently he is from New York State, Your Honor, and has a mother up there that's not doing well, and he is actually moving back up there as soon as he can. I think he'd be a great candidate for probation.
What county is that in New York? I don't know.
And he's very remorseful about the whole situation. It's kind of embarrassed, to be honest with you, but
As they should be, two
Yeah.
grown men challenging each other to a fight in a parking lot.
well, they teach fighting, so they they maybe let it roll over a little too much. But yes, you're right. You're very correct.
All right. Do you have employment? Where are you going or? And what will you be doing? Doing what?
Teach martial arts, self-defense, like not getting hit. It's called.
Not offense, but defense. All right, this is what the court will do. The court is going to sentence you to 6 months in the Bexar County Jail, suspended and probated for 1 year. regular reporting by Zoom or in person, $500 fine. That will be probated.
Thank you, Your Honor.
Transfer to Manhattan, New York. Proof of employment within 45 days, no employment as a home healthcare provider or with minors. 200 hours community service restitution. I'm going to order anger management. Once that's completed, 100 hours of community service will be deemed satisfied. Do you have any children?
Yes,
What are their ages?
31 to 20.
I'm sorry?
31 to 20.
All right. Do you have any grandchildren? There's to be no contact with Mark Langon, Langon. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. Grown men fighting in the streets, what have we come to when we're arguing over what fighting style is the best? And so what fighting styles were you all using? What was somebody doing Muay Thai and somebody's doing something else?
Well, he was a bigger gentleman to me, but because I'm the defensive man, I should have walked away.
You should have. It's not like Mortal Kombat.
Yeah.
You know, get over here. All right, good luck to you, okay?
Thanks, Your Honor.
You're welcome.
Yeah, good to see you.
You too.
Okay.
Stephanie Navarro.
Next time I'll call you.
Slide cases, gentlemen. Cases.
Court is calling 2025 CR 013459 State versus Stephanie Marie Navarro. Can I have parties announced?
George John Mark for the defendant.
And are you Ms. Navarro? Yes, ma'am. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Navarro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Mm.
Anyone promised you anything other than the plea?
Mm.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be denied naturalization and re-entry. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at an $800 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions, that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not at this time, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 200 hours of community service restitution, and the life skills course. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
It offers stage 1 in the top group.
No objections, Your Honor.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, this is a first time offense for a drug offense, Your Honor. And so we had discussed some issues that she had some concerns about the case, but she feels it's in her best interest to plea, and we're asking that the court grant her request for deferred adjudication.
All right, do you have any children?
Yes.
What are their ages?
I have 7 children. Their oldest is 22, 21, 18, 17, 16, 10, and 8.
All right, and do they live with you? And is Child Protective Services involved in your life?
No.
And if you're drug tested today, what are your results going to be? And you need to be honest with me because I'm going to have you drug tested.
I will come out. I take a internal health control, what is it called? ADHD pills.
Okay, so here's the thing. This charge is a charge for methamphetamine. My question is, are you going to test positive for illegal substances?
I believe so.
All right, and what would those illegal substances be?
It would be for the ADHD pills. I think.
Your Honor, I think she's a little confused.
So here's the thing. Do you have a prescription for ADHD pills? ADHD pills? All right. Have you been taking anything other than that medication? When were you prescribed that medication?
It's about almost a year ago.
And how long have you been taking them? Just a year ago? Are you going to be positive for anything else? And Child Protective Services didn't get involved in your life, even though you had this case? So who else lives at home with you other than your children?
My mom and dad.
All right. Are they employed or no?
Yeah, my dad is.
But your mom isn't?
No.
All right. I'm going to order 200 hours of community service restitution, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Are you currently employed?
Yes, sir.
Doing what?
I do hair for a living.
Okay. All right. I'm going to order parenting classes. 100 hours will be deducted upon completion of the parenting classes. How far did you go in school?
I graduated.
Okay, awesome. Thank you. And do you have your cosmetology license? Oh, congratulations.
Thank you.
And then 100 hours, the remaining 100 hours will be deemed satisfied once she completes the life skills course. There's going to be field visits 1 time per month for 6 months. Probation, is there anything else?
Yes, Judge. Term.
Oh, I'm so sorry. I wrote it in and I didn't say it. 2 years, deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Is there anything else?
No, sir.
Is there anything else you need from the court to be successful?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, we can go off the record. In this court, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back to court, okay? All right, good luck to you.
All right, thank you, Your Honor.
Judge, was there a fine?
Hmm?
Was there a fine?
No. Oh, yeah, I did say $800 prorated. Oh, no problem.
Oh, you said 800.
Yeah, I did not say that. Okay, it's $800, but I probated it.
Thanks, Judge.
See, I'm starting to do this paperless thing, so I'm just putting thing in the system and I'm assuming I've said it. All right, who do we have in custody over here? Who has somebody who's in custody?
Good.
All right, come forward. Who do you have? Dylan Smith. Are you all ready?
Your Honor, I'm not quite sure what we're gonna do, because he's willing to plead true to his technicals, but we, this time, are not willing to waive the number ones. This is our first setting, so I'm trying to get information on the number ones. They're out of county. And I've been working on that, all since the lunch break, but I haven't gotten enough information to know if I'm in a position to waive them or not.
All right, Ms. Ferguson, set this for a contested hearing
Okay.
in 2 weeks.
2 weeks.
Mhm.
You need a December, Judge.
All right.
December 1st.
All right, December 1st will be your contested hearing. All right, thank you.
Have a seat, sir.
Judge, I have an MTR and a trial case.
All right, just give me a moment. Let me get rid of the people in the box.
Talking about those two. Yeah.
All right, who is it?
Mr. Duenas is an MTR and Felix Beltran is a trial.
Are y'all ready to proceed on the motion to revoke?
Actually, the state was trying to get hold of their complainant. They weren't able to do that.
Been trying since this one, trying to vote conviction, all the number of different phone numbers and sent emails that had not been able to, so we just asked for recess.
All right, Mr. Joines, come down, please.
Judge, we also have a motion set bond on that case set. Not filed, better put.
All right. What I'll do is to address your bond matter, if the state, if you have no objection to notice, we'll recall it for tomorrow.
As far as notice, I do not object to notice.
All right, so we'll recall him for tomorrow.
Okay.
It'll be for the bond and it'll be for you all to see if you can get in touch with your complainant, and then I'll set the MTR.
Thank you, Your Honor.
All right, who else do you have over there, counsel?
Mr. Beltran, Judge, he was actually specially set Monday.
Okay.
But then he got moved because of the change of schedule.
And is he set for jury trial?
Yes.
All right, we have one that's ahead of him. So Norma, call Mr. Beltran for tomorrow
Yes, sir.
and we'll know where we are.
Okay, Judge.
Want him judge?
Yes. All right, who else has someone who's in the box? All right. Mm-hmm. Oh, come down, please. Hello. All right. All right, so what we're gonna do, there's one case that is ahead of yours. So we're gonna recall you for tomorrow. Okay? And she'll be brought over dressed how she's dressed today. Counsel, if you wish for her to be dressed into something else, you will need to call the jail and see if they can accomplish that. They have a new rule that you have to let them know within 72 hours.
Yeah, I'm not gonna make that.
But
Can
if
I
you
bring,
need me
can I
to
have
sign
somebody
them-
bring clothes over here so you can switch out?
Oh, no, we can't switch them out here. But if you just present a motion, I'll sign it and ask them to expedite it.
Okay. Thank you, Judge.
Thank you. All right, who else is in the box? that I have not spoken with?
Johnson, Dar,
All right, are the parties ready on Kazar? Who's with Kazar?
it's not less of Judge.
All right, recall him for tomorrow. And who else? That's it. All right, yes.
Good morning, good afternoon. Judge, I had a case this morning that you just called for tomorrow. Didn't look on my calendar when you did that. I'm set for file on a divorce case tomorrow that I think is gonna eat up the entire morning.
Mhm.
Can I get that recalled for Friday?
And who is your client?
It was Jessica Cantu.
Let's do it. I did first. I don't want to try this.
Let me see here. Norma,
Yes, ma'am.
on Jessica Cantu defense say they have a jury trial scheduled on the civil side. Can we recall this? When do you want to recall it?
Into the first of December, Judge.
All right, December 1st. Thank you.
Thank you.
Okay.
Yes.
So, the Coopers, Felicitas and McCall that are set on next week's docket, in getting ready for next week, filed a couple more specific motions. One's actually a Brady one. One is, asking this witness, I've already confirmed with the state, they are in agreement. So I brought you the physical copies with the orders.
For the record, one of them is what's consumed as wanting some medical records related to the victim.
If they exist, I can try and reach out, but if they do exist, I may not be able to have them in time for Monday's jury trial session.
All right.
And I understand that one being on the tardier side, like if I have to adjust and shift on the fly, that's fine, I get it.
Well, I mean, you all agreed that you're going to get this or try to get this, so
So I'm gonna,
I'll take these motions up at that time. But y'all need to do that off docket. Okay.
What was that make?
Judge, it looks like we have two of them out on the probably still in the Friday. One of them is Luis Martinez, client. He just started, he needs to really count.
And who is this? Jesse Garza?
Jesse.
All right. Have them come back tomorrow. And who's the other person?
We really like.
David Guerra,
Those are fun. I did too.
Ed Garza's client, Ed Garza said.
What page is he on?
Page 8.
All right, it'll be tomorrow.
All right.
That one. I could make it work.
Jesse Guerra. Jesse Garza.
Yeah. You want to take a look at it?
Garza and Guerra.
That works. And who are these people on Zoom?
They bonded. They're trauma bonded.
For what purpose?
Pregnant pause. Convicted of pregnant women who got.
go Mayor.
Hey, if y'all wanna come pick my jury form.
Yeah,
$100.
What kind of case is it?
I just saw.
Okay, all right, thank you. So I think we just need
Number one,
3.
come on.
Mhm.
First row, they're numbered.
Okay.
We need to, once they start asking questions, you go, just keep on going until you see your number. Number 8, second row. Okay. $15 on the bench. $22, next row. Yes. 30, next row. $37. $51, next row. $7. Relax.
All right, everyone, please be seated. All right, everyone, good afternoon. All right, so that's a slow reaction time. We're gonna try to, oh, Deputy Laura, I think there's some students at the back entry.
It's fine.
Oh, okay, all right, thank you. All right, so we're gonna try that again. Good afternoon, everyone. Oh my gosh, see, now I know everyone is awake. I am Judge Stephanie Boyd of the 187 District Court. You're on the 4th floor. You're in the 187 District Court. Where are we? What floor? What's the court number? Who's the judge? You guys are really on it because usually people trail off when you're singing Old Lang Syne. You know the first bar, but then you just start trailing off. You're probably asking yourself, why am I asking that question? You know where you are. You've been standing out in the hallway. The reason why I asked that question is because I want you to have it at the forefront of your mind. Whenever we take a break, that means that everyone takes a break. So everyone has to leave the courtroom. And believe it or not, we've had people who have gone missing. They say, I looked up, everybody was gone. And then they're down the hallway trying to be on another jury, and the deputies have to go and find them. So you now know where you are. To my left is the court reporter. I want you to raise your card if you want to make her job hard today. All right, so I take that everyone wants her job to be as easy as possible today. This is how you can make her job easy. Number 1, the tone that I am speaking in, that is the tone you need to speak so that she can hear. The acoustics in this courtroom, they are not good. Can everyone in the back hear me?
Yeah.
So this is the tone that you need to speak in so that the court reporter can hear. The other thing is, I know sometimes when we're talking to each other, we tend to talk over each other, finish each other's sentences. Do not do that because the court reporter has to take down everything that everyone is saying. Now, if we all talk at once, will she be able to take that down? Of course she can. No, she can do it, but we're making her job easy. All right, Cindy just shook her head. She's like, no, I cannot do that. But we want to make her job easy. This is the other thing. Only one jury pool has been able to follow this instruction. I have faith that you all will be able to follow this instruction. Everybody raise your card. Do not lower your card until I tell you to lower your card. Jurors 1 through 21, lower your card, please. Everyone else, if you still have your card up, that means that whenever you're answering a question, whenever you're asking a question, I'm going to need you to stand so that Cindy will be able to hear you. Can everyone promise that you will do that?
Yeah.
All right, you can lower your card. And whenever you have a question or if there's something you cannot hear, please raise your card and wait until someone calls you by your number. So I've introduced Cindy, I've introduced myself. The other people that you will see coming back here, you can see some empty chairs. Usually we have students. Sometimes we have court reporters who are studying to become court reporters. They will come in and they want to practice taking a record, but Cindy is the official keeper of the record. Sometimes we will have students who will come, and the reason why they're coming also is because they're in law school or they're thinking about going to law school and they want to see if this is something that they want to do. So this is the state of Texas versus Johnny De La Rosa. State, if you can introduce yourself, please.
Good afternoon. My name is Megan Galloway and I represent the state of Texas. My name is Lauren Espinoza and I also represent the state of Texas.
And for the defense?
Robert Maurer for Johnny De La Rosa. Trey Maurer for Johnny De La Rosa.
Johnny De La Rosa.
Okay. And then state defense, the person who is sitting here. The lady back here.
That's his mom.
All right. So that's Mr. De La Rosa's mom. Courtrooms are to be open to the public. So anybody who wants to come in and watch, they're welcome to come in and watch. So she's not participating. She's not going to be asking questions of you all. She's just here to watch this process. Does everyone understand?
Yeah.
All right. So now the charge in this case is aggravated assault with a deadly weapon. Normally people say, you know what, I would love if I could get an accident case where it's next door at the historic courthouse. But in order to have jury trials, we need jurors. Does everyone understand?
Yes.
And before I go further into this case, you've had a chance to have the parties stand and introduce themselves. Is there anyone here who recognizes any of the parties? If you do, please raise your card. All right. Now, I've told you the charge is aggravated assault with a deadly weapon. That is what Mr. De La Rosa is being accused of. When the state and the defense speak to you, and they get to ask, they're each going to have 30 minutes to ask you whatever questions they want to ask of you. They are not allowed to tell you what they think the facts are of this case. So anytime they speak to you, they're going to be speaking to you in hypotheticals. The only time you will know what people think the facts are in this case, just one moment. Sometimes students are afraid to come in. All right, the only time you're going to know what people think the facts are in this case is if you are selected to be a juror. Does everyone understand?
Yes.
So don't be like Mrs. Kravitz from Bewitched and say, oh, those are the facts of the case. You will not know unless you are actually a juror. Does everyone understand?
Yes.
Now, I want to talk to you about indictments. What are indictments? An indictment is just a piece of paper telling somebody what they're being accused of. It is not evidence of anything. Let's practice raising our cards. Raise your card if you've ever been charged or been pulled over or had some type of traffic ticket before. All right, I will tell you, this jury pool is some of the worst drivers we have seen here today. All right, you can lower your card. I too have been pulled over. And I want to say I was about 18 or 19. So here I am, 21, and I haven't had another. Hey, that shouldn't be that much laughter to that. You should say, wow. So let's say, and when I got the time that I got a ticket, it was at the time when the officer had the notepad with the carbon copy. Now I think they do it electronically or something. So let's say an officer pulls you over and the officer is saying that you ran a stop sign, right? So they pull you over and they say, hey, you ran a stop sign, and they write you out your ticket and they give it to you. And usually they have little boxes on there, I think, where you check speeding, stop sign, or something else, or yield sign. And so they check the box that says you ran a stop sign and they give it to you. And at the bottom of that ticket, it'll tell you where you appear. And usually it's municipal court on Frio or somewhere. So you accept that ticket. When you accept that ticket, you're not telling the officer, yeah, you're right, I ran a stop sign. You are receiving that ticket. So you'll know this is what you're being accused of, and this is where you need to appear if you want a jury trial or if you want to enter into some type of an agreement. Does everybody understand?
Yes.
So an indictment is the same thing. It's just to tell somebody what they're accused of. Can you imagine if you got a traffic ticket and it said, the officer said you ran a stop sign and you're like, I'm ready to go to trial. You know, I'm not guilty. I'm ready to do this. And then you get there and they say, surprise, you really ran a red light. That's what we're here for. So it's to give, the indictment is to give somebody notice what they're charged with, where they need to appear to answer. Does everyone understand?
Yes.
So an indictment is not evidence of anything. It can not be used by you to prove anyone's guilt. It can't be used by you to prove anything. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. De La Rosa because he's here under indictment? If you are, raise your card. All right, now the next thing I want to talk to you is the right to remain silent. Where are my practice people, The Good Wife, Paper Chase? Anybody seen those shows before? Beretta, Mannix, Barnaby Jones? All right. So this is what I can tell you. Everybody has a right to remain silent. I've been a defense attorney. I've been a prosecutor. And guess what? As a defense attorney, sometimes I would have clients and I would talk to them in the office and I would say, hey, I don't recommend you testify because you're nervous with me and I know you didn't do it and I'm on your side. So it wouldn't be good for you to testify. Sometimes I would have clients, they're just so afraid of testifying. Sometimes I would have clients who would have a speech impediment. Sometimes I would have clients and we'd be in the middle of trial and they'd say, you know, hey, I want to testify. And I would tell them, I don't think you need to. The state didn't prove their case. The reason why I tell you that, there's a host of reasons of why somebody would not testify in their defense. Does everybody understand that?
Yes.
Usually what I get when I speak to people, people are always like, yeah, if that were me, I'd get up on the stand. I'd want to tell my story. And I always laugh at that and I would chuckle at people because I'd say, but it's not you. And you don't have a professional who's probably giving you advice on what to do. You know, it's similar to if you have a doctor and you choose that doctor to perform heart surgery and they're telling you, hey, this is the scalpel I'm going to use or whatever. You don't say, well, wait a minute. That's not the scalpel I would be using. So it's the same things with attorneys. But the key is our Constitution says that everyone who's charged with a criminal offense has a right to remain silent, which means they don't have to testify. You can't hold it against them if they don't testify. You can't deliberate and say, well, I wonder what they would have said. You know, they should have said something. So that's a strike against them. And the state can't call them to testify. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. De La Rosa if he decides not to testify? Is there anyone here who's going to consider it at all if he decides not to testify? All right. Now, the next thing I want to talk to you about is presumption of innocence. What does that mean? Everybody who's charged with a criminal offense is presumed to be innocent. Every single person is presumed to be innocent. Unless and until the state, well, I'll strike that. Everyone is presumed to be innocent. So what does that mean? That means that if there's someone who is trying a case against an accused, they have to prove them guilty. And they have to prove them guilty beyond a reasonable doubt. Does everyone understand?
Yes.
So what does that really mean? That means that the state has the burden to prove somebody guilty. Does everyone understand?
Yes.
And they have to prove each and every element beyond a reasonable doubt. Does everyone understand?
Yes.
The defense does not have to prove anything. So if ever you're deliberating and you say to yourself, well, I wonder why the defense didn't bring this piece of evidence or why the defense didn't do that, you know that you have shifted the burden and you're trying to make the defense prove something. The defense does not have to prove innocence. Does everyone understand?
Yes.
And when you're thinking about deliberations, deliberations is really not whether somebody's innocent or not innocent. Deliberation is really about whether the state proved their case beyond a reasonable doubt. Does everyone understand?
Yes.
So, proof beyond a reasonable doubt. What is the definition of that? When I was in law school, there was a definition. You had to know it. If you didn't know it, you felt like a failure. My first jury trial that I ever had, I said the definition perfectly. I knew where to put the comma. I knew where to put the exclamation point. I knew where to pause for dramatic effect. But after that first trial, you know what ended up happening? There is no longer a definition for proof beyond a reasonable doubt. So the state can't give you a definition and the defense cannot give you a definition because there is no definition. So in my different hats, I said, well, how do I explain to a jury what it is then? And so I would just tell a jury what it is not. Next door, you have the historic courthouse with the green rooftop. They have two burdens of proof over there for their cases. One is when you have the car accidents, the fender benders, and different other civil matters, they have what's called preponderance of the evidence. That's more likely than not that something happened. If you're ever deliberating in Texas on a criminal case, doesn't matter if it's a misdemeanor, a felony, or whatever it may be. If it's a criminal case and you find yourself deliberating and you say, more likely than not this happened, you know, you are not at the right burden of proof and you need to remind yourself, wait a minute, I'm not in the historic courthouse, so therefore that should not be the burden. The other burden they have over there is what's called clear and convincing evidence. Clear and convincing evidence is the burden of proof that is required to terminate your parental rights. They say you're a danger to your child. We will no longer allow you to parent the child. Now, proof beyond a reasonable doubt is the highest burden we have in Texas. And that is higher than preponderance of the evidence, and it's higher than clear and convincing evidence. Does everyone understand?
Yes.
Now, I want to talk to you about fairness and what does fairness mean? Because people will always ask, can you be fair? And this is the hypothetical that people normally give. You're scheduled for jury duty. You make plans. You navigate the route that you're going to take. And then you say, you know what, let me just drive it too, because there's a lot of construction and I want to make sure I'm downtown and I make it on time. And then you say, I want to check out the parking situation. So you do all of that as your test run. And you get up extra early in the morning, you make your breakfast, you come down, you're like, ready to do my duty. And when you come down, you find out that your vehicle is on cinder blocks. Somebody has stripped your car. They've taken your valuables that were in your car. They've taken, what do you call it now? Not the radio or the deck player. They've taken everything. They've taken your music. But you say, you know what? I want to do my civic duty. So you get your neighbor, or you take the Via bus or Uber or Lyft, and you come downtown. And you wait in the hallway. And then when you come, you find out you're going to be sitting on a burglary of a vehicle case. Usually people will say, this really is not the case for you, is it? Because you just had your car burglarized. And then some people will be like, yeah, no, this is really not the case for me. I don't know if I can be fair. This is what fairness is about. Even though if that hypothetically would have happened to you and you find out you're in a case where it's a burglary of a vehicle, the question is whether or not you would be able to make a decision, if you can come to a decision, based upon the facts that you hear in that specific case, and not be saying, you know, in the back of your mind, you know what, my car was just burglarized. I don't care if this guy did it or not. I'm going to find him guilty. Does everyone understand?
Yes.
So that's what fairness is, because we've all had our trauma. We've all had issues. Raise your card if you were born yesterday and slept all last night. Nobody fits that category. So what that means is that we all have had issues that have happened in our life. So when people ask you whether or not you can be fair, for example, in this case, I'm going to ask you whether or not you can be fair. What does that mean? That means that will you be able to listen to any evidence that's presented to you and base your decision, if you can come to a decision, on the evidence that's presented to you? Is there anyone here who cannot do that? All right, that's number 30 and 65. Do you have yours up? Are you number 6 or 9? All right, 6. All right, number 30, I have you, and 65. Now, the next thing I want to talk to you about, jury trials. There are 2 phases to a trial in Texas. The first phase, people love to call it the innocence phase, but it's not. The first phase is really whether the state proved their case beyond a reasonable doubt or whether they did not. That's the first phase. Did they prove their case beyond a reasonable doubt? Or were they unable to prove their case beyond a reasonable doubt? If they're unable to prove their case beyond a reasonable doubt, what should your verdict be?
Not guilty.
All right, we're going to say that again. If the state is unable to prove their case beyond a reasonable doubt, what should your verdict be?
Not guilty.
All right. Now, if the state proves their case beyond a reasonable doubt, then what would your verdict be?
Guilty.
All right. So if the state doesn't prove their case beyond a reasonable doubt, that means that's a not guilty. There's no phase 2. If the state proves their case beyond a reasonable doubt, then the next thing, there is a phase 2, and that's called the punishment phase. Now, the range of punishment in this case, this is an aggravated assault with a deadly weapon. The range of punishment is potentially probation or either 2 to 20 years in the prison. Does everybody understand the range of punishment? Now, as you can see, that is a wide range of punishment, because when you think about it, maybe somebody is deserving of probation. Maybe somebody is deserving of 2 years, 3 years, 4, all the way up to 20. Does everybody understand?
Yes.
Now, sometimes people will say in certain situations, there's no way I could ever consider probation. There's no way I could ever consider 2 years. There's no way I could ever consider 20 years. But what usually happens during a punishment phase is if you found somebody guilty of something, then there will be other facts that will be presented to you, along with whatever facts that were presented to you in the guilty, not guilty phase. And you would take those facts and try to come up with what you believe would be an appropriate range of punishment. Does everyone understand?
Yes.
For example, at one point in time, you could actually get probation for murder. You can no longer get probation for murder. So now the range of punishment is 5 to 99 years or life in prison. And when you talk to people about murder cases, sometimes people knee-jerk reaction. Oh, I'll never consider 5 years. Sometimes people will say that. Then I give them a hypothetical. So let me give you a hypothetical. Let's say someone is charged with murder, and you have their school teacher come in, and their school teacher comes in and he says, you know what, Johnny, I always knew this is where he was going to end up. Johnny came from a great family. Johnny used to pull the wings off of butterflies. I remember there was a little old lady walking across the street. He kicked out her cane, and then Johnny ends up killing somebody. That may be somebody where you say, you know what, Johnny should get a stiff sentence. But let me give you another scenario of murder. You have this couple. Their families were best friends, and they always said, you know what, I've had a baby girl, you've had a baby boy. Wouldn't it be great if they got married? So they were always putting them together, like preschool, they're together, kindergarten, they're together, high school, and they were high school sweethearts. They grow up, they end up having children, and then one of them ends up getting terminally ill. And the doctor comes in and the doctor tells the spouse, look, there is nothing we can do. We can barely keep them comfortable. They're going to be in excruciating pain for the little time they have left. And that spouse comes in and talks to their spouse, and the spouse says, you know what, I've had a great life. Can you just help me end it all? I will need you to help me. I've saved up the pills. Can you give me the water? Can you, put the tablets in my mouth? And they do that and that person dies. Guess what? That's murder. So in that case, maybe you'd be on the lower end and you'd say, yeah, I could see where I would consider 5 years for that person. So has everybody had a chance on an aggravated assault with a deadly weapon? Has everybody internalized the range of punishment? So range of punishment, if someone was found guilty, potentially probation and anywhere from 2 to 20 years in the prison. Does everybody understand?
Yes.
Is there anyone who cannot consider the full range of punishment? And when I say consider, I don't mean give, because you don't know what you would give unless you have facts. So can you consider the full range of punishment? Is there anyone here who cannot do that? If you cannot, raise your card. All right. That is 43, 51, 63, and 64. You can lower your card. Now, the next thing I want to talk to you about is languages. I think languages are great. I love languages. When I was in undergrad and grad school and law school, I was surrounded by people who spoke many languages. One of my classmates actually spoke six languages. And I could probably say hurry up in every language because that was what I was able to learn. I'm originally from Louisiana. You can always tell I'm from Louisiana when I have to say words like all and soul. When I was in junior high, my best friend said, Stephanie, we should take Spanish. And I'm like, why would I take Spanish? I'm never going to need it. I'm in Louisiana. I'm going to retire in France at the age of 21. And lo and behold, here I am in San Antonio, not having taken Spanish, but I'm slowly learning it. If I don't know it as well as I should know it, that's the deputy's fault. But I'm working on it. So is there anyone here, raise your card if English is not your first language? All right, we have 7, 15, 26, 27, and 73. All right, number 7, what's your first language?
Kirkman.
Okay, and how do you say hurry up?
Satwal.
Satwa. All right, thank you. Have you been able to understand everything?
I have.
And how many languages do you speak?
3.
And they are?
Russian, Turkmen, and English.
And how do you say hurry up in Russian?
Быстрее.
Thank you. I don't want to lose my knowledge of that. All right, thank you. Number 15. And have you been able to understand everything?
Yes.
Thank you. Number 26.
Spanish.
We're making her job easier.
That's
All right.
Spanish.
Have you been able to understand everything?
Yes.
Thank you. 27.
Spanish as well.
And have you been able to understand everything? Thank you. 73.
Spanish.
Have you been able to understand everything?
Yes.
All right, thank you. Now, I am going to tell you 2 stories, both of them are true. The first story, I always tell this story because I think people need to hear it. Jury duty is an inconvenience. Why do I say it's an inconvenience? Because you have to come downtown, you have to pay for your parking, you have to stand in the hallway, you have to hurry up and wait. That's why it's an inconvenience. But when you think about it, your government only asks 2 things of you. Pay your taxes and come to jury duty once in a blue moon. Raise your card if you've ever served on a jury and actually sat and heard evidence. All right, so that's 2, 4, 33, 34, 51, 54, 59, and 60. And of those people raise your card if it was for a criminal case. All right, that's number 4, 34, 51, 54, and 60. And number 2. And of the people who raised your cards, how many of you had a verdict in your case? All right, that's 51, 2, and 4. Thank you. All right, so this is what I consider a sacrifice. My family grew up in a small town called Grand Cane, Louisiana. My uncle was super intelligent. And that was back in the day where the teachers not only knew every student in their class, they knew every student in the school. So they would tell my grandmother, they would say, Miss Lane, we've taught him all we can teach him. And they would pass him to the next grade. Now, when his sisters and his brother started school, they didn't like that too much because the teachers let them know. Your brother's the gold standard. You all had better bring some knowledge here. So he ends up graduating. And when he graduated, there's a conflict that breaks out. You may have heard of it, called Vietnam War. Now, my grandmother had a 6th grade education, but she was super intelligent. When my mom would work, she taught me how to read, write, tell time, not this digital thing that you all do now, but with a clock, with a face and the big hand and the little hand that became the minute and the hour. She taught me how to tell insurance salesperson, we don't want any. So he comes to her and he says, hey, with things that are going on, no civil rights, nothing's really happening here. And I can't get ahead here with the way things are. I'm going to join the military and can you sign me up? I always tell people that's a sacrifice because guess what? That's our firstborn. And parents, regardless of what you say to the middle child and the baby, there's something about the firstborn. So if you can imagine during those time frames, my grandmother had a television set, but that was ABC, CBS, and NBC. And you really couldn't count on NBC because if the wind is blowing or there's a little static, you're not going to pick up anything on NBC. TV would not, all this thing where you have an insomnia, you're just like, oh, what can I watch over these 300 channels? Didn't have it, only those 3 channels. And at a certain point in time, programming ended. And you would know that it had ended because either your television would just have the white noise on it, or either they play the national anthem to let you know programming is done for today. This whole thing where you can get on your computer and type somebody an email, she didn't have that. The whole thing where she would be shocked if she were alive today that you could actually pick up a phone and have a video phone call with somebody or send a picture, take a picture in one place and send it to the next place. She didn't have any of that. She did have a telephone, didn't have any numbers on it. So what does that mean? You pick it up, the operator would answer. That's why you would have those songs like Beechwood 45789, because operator, I would like to have Beechwood 45789. Now, the operator didn't like her girls because anytime a song came out on the radio, they pick up the phone and ask for that number. But she sent her firstborn off. She had his name, she had his number. That was it. And a lot of the males in my family are in the military. So I know when you get to your location, they'll have you send a letter back to let everybody know I arrived safely. So that's what she was depending on for communication, just the mail. And I would always end that story that way. But then Deputy Laura would say, Judge, did he make it back? What happened? So my uncle did end up getting shot. And he did make it back, though. He has since passed. That's why whenever I smell Old Spice, because that's what he used to wear and the men in the military would always wear, it always brings back great memories. So I tell that story to let you know that that's a sacrifice. This is just an inconvenience. We just had Veterans Day and people want to wave their flags. I'm like, you can wave your flag for your country by serving on a jury. The next story I'm going to tell you is about one of my friends who practiced civil law. She got called up for jury duty and she asked me, hey, Stephanie, let's do lunch. I'm like, great, let's do lunch. We do lunch. And this is when I was a defense attorney. And I asked her, how is jury duty going? She's like, it's going great. I'm like, that's shocking. Why are you saying it's going great? She's like, I'm not going to be selected. I said, why do you think you're not going to be selected? She said, because it's just like law school. I'm on the back, I'm keeping my head down and I'm not saying anything. I start laughing. She asked, what's so funny? I said, I'm happy. And she said, why are you happy? I said, because we're going to end up having lunch all week. So other than staying silent, the quickest way to be on a jury is raise your hand and say, please pick me. Each side is only going to have 30 minutes to speak to you. They're trying to get to know you. They're not going to have chance to go out to your home or invite you to lunch or dinner. This is the only time they will be able to speak to you. So share your views with them so that they can make informed decisions on who would be best for this jury. All right, does anyone need a break before I turn it over to the state? All right, so if you'll lower your, yes.
Six.
All right, if you all will lower your carts, we're going to take a 10-minute, should I do 10 minutes or 15 minutes? 15? All right, so everyone look to your left, look to your right. You're responsible for that juror. So you all can use the restroom. Remember, you're on the 4th floor, 187th, and do not come back in the courtroom. I'm gonna need y'all lined up in the order that you're in now, okay? So have you all back here at 3:15.
One goes.
Figure number two. If one goes, everybody has to go.
16 came back?
Yes.
He's back, Judge.
Okay. Who was in charge of looking out for number 16? I want to see 15 and 17. We thought somebody was gonna be lost.
Need a cough drop?
No, I'm good. About my halos.
Oh.
But that's okay. I'm done.
We'll save you.
Yes. We'll say, you got that 911 speed.
Oh. Thank you.
Everybody.
All right, everyone, please be seated. And I was reminded there was one question that I forgot to ask you all. So I'm expecting this trial to be concluded by Monday. Is there anyone with any time constraints?
By Monday?
Yes. All right, that's 3. When I call your number, please lower your card. 3, 6, 14, 15, 16, 22, 26. All right, 20, you can't wait till the last minute. 20, 22, 26, 28, 32, 35, 37, 39, 42, 43, 46, 47, 49, 50, 51, 52, 53, 55, 61, 62, 66, 72, and 74. Number 3, what's your time constraint?
I have a vacation plan, so I will be leaving on Sunday. But if there's a need, I can always move the vacation up by 1 day if you're able to go finish on Monday.
All right, thank you so much. Number 6.
I have work scheduled for that day and I'm on low income, so.
Right, thank you. Number 14.
I have a 5-month-old and a 4-year-old that I don't have childcare for, and I'm nursing. So Tuesdays and Thursdays are only part-time. Monday, Wednesday, Friday, so I have no one to watch them.
I'm so sorry. Could you repeat that?
I have a 5-month-old and a 4-year-old that I don't have childcare for on Tuesdays and Thursdays, and I'm also nursing. So I have no one to watch.
All right, thank you. Number 15. Where are you headed? And for what reason? Okay. Number 16.
The same, I have travel plans, supposed to be leaving on Sunday,
And where are you going?
Houston,
For what purpose?
for pleasure.
22.
Horse that's getting a CT scan on her leg. She has a bone infection and they have to do surgery on her, and I'm supposed to take her to Navasota tomorrow.
I'm sorry, where?
Navasota, Texas.
All right, thank you. 20.
I'm hosting my staff on a staff retreat this Sunday from noon to 6.
All right. And what day?
This Sunday,
Sunday, noon to 6. And where is this?
the Girardi's Ranch.
All right, so just so everyone know, we're not planning on working on Sunday or Saturday. We're not working on the weekend. So when is your staff retreat?
Sunday.
Sunday. All right, thank you. 26.
Sorry, I misunderstood. I'm able to come.
All right, thank you. 28.
I do high school football and I have a playoff. I have I do high school football and I have a playoff game in Del Rio on Friday night.
Friday night?
Yes, ma'am. I have to get to Del Rio.
All right, and who's the team?
Hmm?
Who's the team?
Del Rio.
All right, and who are you playing against?
I'd have to look that up.
All right, because if it's my high school team. All right, thank you. Number 32,
I'm a single mom and I have nobody to get my daughter after school.
and what is,
School for me, middle school,
what time?
3:45, she gets out for 3:50.
All right, 35,
I also have travel plans going out to the country on Thursday.
and where are you headed?
Paris.
Now, are you really going to Paris? You're just trying to pull on my heartstrings. How long are you going to be gone? Okay, all right, thank you. 37, wait a minute, is that Paris, Texas? Okay. Number 37,
Coach the water polo team, and I'm supposed to leave Friday morning for Dallas for a tournament and Sunday night.
so you're leaving Friday? All right. Again, what team are you playing?
We're playing 4 different teams.
Might that be one of my school teams? Okay, all right, thank you. Number 39,
You're also on Friday.
I'm so sorry to hear that. Thank you for letting us know. 42,
I mean, travel plans, I'm leaving, tomorrow's Thursday, yep, leaving for Dallas business trip.
all right, thank you. 43,
I have some medical issues.
all right, thank you. 46,
CEO of a development company, and I just looked at my calendar, I had 12 meetings 3 months.
all right, thank you. Number 47,
I have to go out of town, Georgetown, building project. Friday.
all right, thank you. 49,
Hi, I have small children that I need to pick up after school
what time?
at 3:45.
Oh, are you all picking up children together?
Oh, no.
Thank you. Number 50,
Leaving tomorrow, Dallas, Monday to the
I'm sorry, for what purpose?
family.
Are these in-laws?
Family.
Okay, all right, thank you. Number 51,
I sort of misunderstood. I thought we were just talking about Monday. I do have a VA appointment.
all right, thank you. 52,
Supposed to be traveling for work tomorrow, to Dallas.
all right, thank you. Are you going with that gentleman? Number 53,
Elementary school teacher, at least a day, 3 days lesson.
all right, I teach at UTSA, I understand, thank you. Number 55,
I have to pick up my son from ABA therapy on Monday
what time?
at 5 PM.
All right, thank you. Number 61,
On Friday, I'm supposed to take my mom to Mexico for dental work. And depending how it goes, she'll have a second procedure on Monday.
all right, thank you. 62,
My brother's getting married on Friday, and as part of the wedding party, I'm helping him set up.
all right, are you the best man? All right, well, now we have more questions. Are there more brothers? Are there more brothers?
Yes.
Okay. And how long is this wedding?
How long is it?
Yes, I mean, does it end on Friday?
Yeah, it's happening Friday.
All right, thank you. Do you want to go? Number 66, all right, thank you. 72,
I have to pick up my granddaughter. She goes into school at 2 and she's out at 4 and for the rest of the week.
I'm sorry, so 4 p.m.?
Yes, 4 p.m. she gets up.
All right, thank you. Number 74, Okay, somebody needs you to speak up. I can't hear.
Okay, I don't know if I'll be able to get a sub for me till Monday. I can do today and possibly tomorrow.
A sub for what?
I work in a school.
All right, thank you. All right, anyone else? Just 1 second. 24.
So I'm an elementary school teacher and the same thing with the sub work. And then I'm also being evaluated too.
All right, thank you. And then,
Maybe just with teaching, I didn't know that was consideration. About those days, being an elementary teacher.
all right, thank you. All right, this is what I'm gonna tell everybody about employment. And this goes for me as well. I've served as a juror before. Here's the question. Are you indispensable at your job? What does that really mean? If you are indispensable, what that means is if you retired, that job would just go poof because there's nobody else who can do that. So with that being said, raise your hand if you're indispensable at your employment, which means if you decide to retire or quit, that job is going to disappear because nobody else can do it. All right, that's number 40. Anyone else? All right. All right, State, you may proceed.
Thank you, Your Honor. All right, good afternoon, everyone. My name is Megan Galloway and this is Lauren Espinosa, and we represent the state of Texas. And so I know you all are probably feeling like, please, please, please don't call on me, but the judge did let you in on the best kept secret in the courthouse, and that is that the people that stay silent are most likely to be on the jury. And so I'm going to ask for you all to be active participants. Okay, if you don't participate, I'm going to have to call on you. That's not really fun for anyone. So let's talk about what the purpose of jury selection is. One, it's to talk to you about the law that would apply in this type of case, to learn about you as our panel members, and to find 12 fair and impartial jurors that are right for this case. Now, the judge already kind of went over that with you when she gave that burglary of a vehicle example. But basically what that means is both sides, the state and the defense, are looking for jurors that can follow the law that is going to be given to you from the court and base your decision solely on the evidence that you receive. Okay, can everyone do that? Yes. Okay. Now, in my jury selection presentation, I have a rule, and it's the no waffling. Okay, so we are in jury trial in this court frequently. And a lot of times I get jurors and I kind of refer to them as like the little engine that could, because I ask them a question and they're like, well, I think I can. And I'm sorry to inform you that that's not really a good enough answer. Okay, so I'm going to ask you all to listen to the questions that I'm asking you, internalize what I'm asking you, and then pick the choice that aligns best with your view. Okay, can everyone do that? Yes. All right. Now, the first question that I have for y'all is I want everyone to answer it. And it is, what is your opinion of the criminal justice system? So I'm going to give you 4 choices here. 1, you think it's terrible and it takes away our rights. 2, you believe it's concerning and it interferes with our rights. 3, you believe that it's helpful and looks out for citizens. And 4, you believe that it's beneficial and protects us from the harmful acts of others. So who aligns with choice number 1? You think that it's terrible? Please raise your card. What about choice number 2? You believe it's concerning. Okay. That is juror. Please keep your card raised until I call your number. Okay, juror number 3, 12, 16, 32, 35, 52, 53, 50, 57, 58, 63, and 65. I got there 17. Okay, and then I'm gonna skip. What about 4? Who believes 4 is beneficial? Please raise your okay, you can just go ahead and put your card here. All right, so let's talk about the element of aggravated assault with a deadly weapon. That is what the state has to prove to you. And that is 1, on or about the offense date. 2, that the offense occurred here in Bexar County, Texas. 3, that the defendant was the actor. Okay, 4, we have to prove to you a mental state. So in this case, it could be either intentionally, knowingly, or recklessly. Cause bodily injury to the victim and did use or exhibit a deadly weapon in commission, okay? And so let's talk about mental states. So the law says that you do not have to be a mind reader, okay? You can infer a mental state from facts and circumstances surrounding the offense. So I'm going to give you the legal definitions. Intentionally is a conscious objective or desire of the defendant to engage in that conduct, okay? So when I think about that, I think, is that what the person meant to do? Okay. Knowingly is defined as the defendant being aware that the conduct is reasonably certain to occur. When I think about that, I think, did this person know that that was going to happen and they chose to act anyway? And then recklessly is a conscious disregard or consciously disregarding a substantial and unjustifiable risk. So when I think about that, I think, did you know that there was a big risk that this was going to occur and you decided to act anyway? So like I said, you're not required to be a mind reader. You can infer this from words, actions, and circumstances. So we're going to explore this through a movie that I love very much. It's called The Titanic. Okay, and so there are 3 actors that you need to be aware of. One's name is Cal, the second is Rose, and the third is Jack. Okay, and so I'm going to give you some circumstances surrounding the act, and then I'm going to ask you all to infer the mental state. Okay, so the circumstances are: 1, Cal grabs a knife from his personal attendant, and Cal starts slashing at Jack and Rose. Okay. While he's slashing at Jack and Rose, he strikes Jack and causes him a laceration to his arm. Okay. What do you all think Cal's desire was? Cause injury. Does anybody disagree with that? What do you disagree with that?
Maybe just to intimidate me.
Raise your card, please. Okay, so you said maybe just to intimidate. Okay, if he's continually slashing.
But I would step away from somebody like that.
Okay, but you're saying it's a possibility that he was just trying to intimidate them, that he didn't actually want to cause them bodily injury?
Potentially.
Okay, does anybody agree with juror number 6? Okay. Now with Cal's actions, what is reasonably certain that could occur? So let's say maybe he was just trying to intimidate them. But if you're slashing and advancing towards someone, what is something that's reasonably certain that could occur? Injury, right? Okay. And that kind of goes the same for the substantial and unjustifiable risk, right? We know that if you're acting with a knife, you could cut somebody if you're acting in that manner, okay? Bodily injury is defined as just pain. And so in the hypothetical that I gave you, those are, that's a successful aggravated assault with a deadly weapon case, okay? Does anybody disagree with that or the application of the law in those circumstances? Okay, so I want to talk to you all about the law of self-defense, okay? It is a possible defense that can be raised. And so what does that mean? That the person that is accused is saying, well, the other person is the one that started it, okay? But let's talk about the law of self-defense. The law of self-defense says that a person is justified in using force against another when and to the degree the person reasonably believes that the force is 1, immediately necessary to protect himself against the other's use or attempted use of unlawful force, okay? And so a reasonable belief is defined as a belief that would be held by an ordinary and prudent person in the same circumstances. So basically what that means is you can respond against unlawful force with force, okay? But you cannot respond against unlawful force with an unreasonable degree of force. And so in talking about self-defense and reasonable degrees, what do you all think are some factors that can help determine whether the actor was acting reasonable? Juror number 2, do you have any ideas? No. Juror number 3?
I think You have to try and justify why these costs being used by each one of those equal.
Okay. Right, and so it's very fact specific, right? So what are some facts if I am a 6-foot male, right? And I am alleging self-defense against another person. What are some factors that we would look at? Like if a 6-foot male is saying, I'm acting in self-defense against this person, and the other person is a 5-foot female that's petite,
Should we
small.
approach-
stature.
Yes.
Order. And so let's say that there's 2 people, right? And one person is charged with assaulting another. If we are looking at whether the person was acting reasonably, let's say that the 2 people, the actor and the victim, are both males, right? But one male is a little taller and heavier than the other. Are those things that you all would be able to consider in determining reasonableness? Does that make sense? Yes. Yes. Does everyone agree that some things that you should consider in determining reasonableness are like height, weight, gender, and maybe even prior interactions?
Yes.
Does anybody disagree with that?
No.
Juror number 44. Okay. And so I'm gonna give you, juror number 12, you disagree with that?
Yep.
Okay, thanks. Now, I want you all to think back a couple of years ago, there was a interaction between Chris Rock and Will Smith, and it was kind of like, I refer to it as like the slap heard around the world, okay? And so what happens is Chris Rock is narrating an awards ceremony, and he's making some jokes about Will Smith's wife. And so Will Smith walks up to him and slaps him right across his face and tells him, hey, don't speak about my wife like that. And so who here, well, I want you all to be clear, okay? The law says that verbal provocation is not enough to allow somebody to try to claim self-defense, okay? You have to be in immediate fear that somebody is using force against you and you feel that your life is in danger and you're going to respond to that force with an equal degree of force, okay? And so in this scenario regarding Chris Rock and Will Smith, is there anyone here that says, yes, Will Smith was justified in slapping Chris Rock just because Chris Rock made a joke about Will Smith's wife?
No.
No. Okay, jurors number 51, 28, and 65. Okay, and so you all understand that the law says that verbal provocation is not enough to use physical force against somebody. If you just had your card raised, please raise again. So juror number 8, 51, and 65, you all understand that the law says that verbal provocation is not enough to use physical force against someone, okay? Do you understand that? Would you be able to follow that law? Please stand up and answer verbally.
No, I believe he humiliated Will Smith's wife in front of thousands of people in the auditorium and those watching on TV.
Okay, and so the law as applied in that hypothetical, would you be able to follow the law and would you be able to follow the law and say, hey, this was not justified under the law of self-defense because the law of self-defense says that verbal provocation alone is not enough?
I understand that the law says it's not justified.
But you wouldn't be able to follow that, is that correct?
I would have to take it into deep consideration.
Okay, and so you're saying you would be able to look at the facts and circumstances, and if the court gave you the law, you would be able to follow the law.
Probably that, but
So I'm kind of gonna go back to my no waffling. I need a yes or no answer, and you're not gonna be judged if the answer is that you can't follow the law, but we need to know.
I could follow the law. Okay, yeah,
You can,
yeah.
okay. The other person that had their card through is 51, would you be able to follow the law or no?
No.
Okay, thank you. 50, would you be able to follow the law or no? What was that? No. Okay. 65, would you be able to follow the law or no?
No.
All right, thank you. 6, would you be able to follow the law? All right, thank you. Now, regarding.
I'm
this
sorry, I didn't hear
interaction-
6 answer.
Sorry, can you say?
No.
All right, thank you.
Thank you. Okay, so when we're looking in that hypothetical that I gave you all about Will Smith and Chris Rock, there's a section of the penal code that says that a person that is being threatened, okay, may also threaten another person with serious bodily injury by producing a weapon, as long as the actor's purpose, so that person that is producing the deadly weapon, is limited to creating an apprehension that they will use deadly force if necessary. So what does that mean? If we're going back to the hypothetical of Will Smith and Chris Rock, that is Will Smith approaching Chris Rock, slapping him, and Chris Rock producing a knife and saying, hey, you better stop it or I'm gonna do something to you. Okay, does everyone understand that law? Okay.
Yes.
Does anybody disagree with that?
Wait, you're saying that's okay,
So the law says that if it's just to, let the person know, hey, if I'm in fear and I'm producing this to let you know that if I have to use deadly force, I will. The law says that that's okay. So does anybody disagree with that law?
No.
Okay. So how does the state disprove self-defense? Okay, so there are a couple of ways, right? One, through witnesses, okay? In any trial, right, the state calls witnesses and testimony is evidence. And so the evidence that you will receive chiefly comes from witnesses that are called. So that's people that take the witness stand and testify to either the investigation they did or if they observed it, what they observed, and things of that sort. That another way is that you are able to examine and see whether the statements are consistent, whether you find the witness is credible, and then we have to go back to that legal test. Okay, were the actions immediately necessary or reasonable? Does everyone understand that?
Yes.
Okay, and can everyone follow the law on that?
Yes.
All right. Now regarding deadly weapons, firearms are per se a deadly weapon, but there is another definition for deadly weapons, and that is anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. And so when we were talking earlier in the hypothetical regarding Rose, Jack, and Cal, the knife in that hypothetical was being used or would be capable of causing death or serious bodily injury. Does everyone understand that?
Yes.
Okay, and so that is a deadly weapon. Does anybody have any questions about that? Okay. So I want to ask you all, what does a victim of crime in Bexar County look like? You're shaking your head.
No, I'm sorry, I just needed you to repeat it.
Okay, so my question was, what does a victim of crime in Bexar County look like?
Anyone.
What is your number? 4. Right, okay, so that's my point, right? Number 4 said anybody, right? And it could be anyone in this room, people that we know and love, anyone. And so would anybody here hold it against a witness if they had, some type of mental health issue or something like that? If you would raise your card.
Sorry, can you repeat that?
So if a witness was called and that witness had some type of mental health issue, would anybody here hold it against that witness?
Do you get to know what they're doing?
Well, it's not. So, who said that?
I don't know, I looked at it, depression, or is it like mental health, is it schizophrenia, is it
Right.
You know.
So I guess basically what I'm asking is, can everyone here keep an open mind and listen to the witness that is called? Because as jurors, you all are the ones that determine, whether the witness is credible, whether you want to believe all of what they said, nothing of what they said, or just believe bits and pieces. And so basically what I'm asking is, would you all be able to listen to the witnesses that are called and make that determination for yourself? Keep an open mind and listen to all of the testimony that they give, no matter what they look like.
Do we know they have a mental health issue or not?
No, it was just a hypothetical, like it was just an example, but so just moving on, like no matter what they look like, no matter what issues that they have, would you be able to kind of disregard that and just listen to the testimony and make the determination for yourself, is what I'm asking.
Yes.
What's your number? 63. Okay, you're saying I don't know. So what is that dependent on?
Now I'm like, or is everyone?
Okay, I can't.
All right, so I'm gonna pause you, everyone. So one, you need to stand where you're talking and speak at the same tone that I'm speaking, because the court reporter has to take it down. All right, you may proceed.
Okay, so can you just stand up, please? Okay, and what is your number? 63. Okay, so you're saying I don't know. So like, if a witness was called, what I'm asking you is, would you be able to look at them, listen to what they're saying, and make a determination regarding their credibility?
I'm just gonna think each one has a mental health issue. I'm so sorry. No.
Okay, because you understand, I mean, that was just a hypothetical.
Yeah.
Doesn't apply. I can't tell you the facts in this case, right?
Correct.
Okay, and so any witness that's called, you would be able to listen to their testimony and make a determination about their credibility, right? Or no?
Yes.
Okay, you have. Now my next question is regarding police officers. Okay, so I'm going to ask you all to rank your view of police officers here in Bexar County, Texas. Okay, and you can choose between numbers 1, 2, 3, and 4. So 1 is you have a very unfavorable view of law enforcement. 2 is a step up from that. 3 is you have a favorable view of law enforcement, and 4 is you have a very favorable view of them. Okay. So who here aligns with choice number 1? You have a very unfavorable view of law enforcement here in Bexar County. Okay. 16 and 65. Sarah, did you have your card up earlier
Yeah,
for choice number 1?
no, I'm a police officer.
Oh, you are, of course. Okay. Who here aligns with choice number 2? That unfavorable. Okay. 3, 35, 39, 50, 52, 62, and 63. Okay, and then who here aligns with choice number 4, very favorable? I'm just gonna have to all put your cards down. So the judge talked about the burden of proof and the criminal case being beyond a reasonable doubt, and she let you know that there's no legal definition for that. And so I can't tell you what it is, but I can tell you what it is not. And that doesn't mean that you're 100% sure, because if you were 100% sure, what does anybody know what that would make you? A psychic. Okay, that's a good answer. Or a witness in the case, right? You were personally observing the things as they occurred at the time they did. Okay, and so I want to give you all this hypothetical, right? And it's that you're an owner of a dog and you come home and the dog is in the kitchen, but there's trash like riddled all over the kitchen. The trash can is knocked over. And so you're like, hey, I don't really know what happened, but has anybody like walked home to that situation before? Okay, number 35 you have. All right, and so if you weren't there, some people would say, hey, you're making an assumption that the dog is the one that knocked the trash over, right? But let's say that the state was going to bring a case against the dog, right? And so we'll call it the state v. Puppers. How would the state prove that the dog is the one that actually knocked the trash over? Well, there can be testimony, right? we can call the testimony of somebody that was maybe watching from their kitchen window and saw the dog maybe jumping up and down in the kitchen. We could bring evidence in the form of photos and testimony of the owner, right? And so you all are able to use your common sense to come to a reasonable deduction of what happened. Does that make sense to everyone?
Yes.
Okay. Does anybody have any questions or would be unable to do that? So knowing that that's the standard beyond a reasonable doubt, is there anyone that would hold the state to a higher burden and say, hey, I need the state to expel all doubt possible for me to be able to find someone guilty? Is there anyone that feels that way? Please raise your card. Okay.
Question, ma'am.
I'm sorry?
Would you please repeat the question, ma'am?
Yes. So my question is that knowing that the standard is beyond a reasonable doubt, that is not defined as beyond all possible doubt. Okay, so my question is there anyone here that would say, hey, I'm going to hold the state to a higher burden and you would need to expel any doubt 100% for me to find someone guilty? So if that's you, please raise your card. 13, 6, 13, 14, 16, 42, 50, 52, 62, 63, 65, 66, 68, 71, 72, 73, and 74. All right, now the and 50.
I might have misunderstood you, but I didn't have,
I'm sorry.
I didn't have my card up. I might have misunderstood you.
Okay, thank you. Now the judge talked to you all about the two phases of trial. What the first is the guilt innocence phase, and then the second is the punishment phase. And so the defendant has elected to have the jury assess punishment. The judge went over the range of punishment with you all. That was anywhere from probation to 2 to 20 years in prison. And so you all said, because you've heard zero evidence, you can consider the full range except for people that did raise their cards. But my questions to you all is, and should we get to the guilt or to the punishment phase
5
of the
minutes.
trial? Thank you, Judge. What is the main purpose of sentencing in your head, right? Is it 1, punishment, 2, deterrence, 3, making amends, or 4, rehabilitation? Okay, so if you align most likely,
Quick repeat on that.
the entire
Yeah.
question.
On the 4.
Okay, so 1 is the main purpose is punishment, 2, deterrence, 3, making amends, or 4, rehabilitation. So if you align more with rehabilitation, please raise your card. Okay. So that is jurors 1, 4, 9, 16,
Hold on, slow down, please.
19, 20, 21, 22, 24 through 27, 29, 32, 34, 48 through 50, 52, 53, 65, 70, and 73 through 75. All right. Does anyone here have a family member or someone that was close to you that was either convicted of a crime or had an interaction with the criminal justice system and you believe that they were treated unfairly? If that's you, can you please raise your card? Okay. And so I'm gonna ask you all to keep your hands raised, because knowing that you have this family member that you feel didn't have a fair shake, would you be able to disregard that? Or would that play into your deliberations in this case? Juror number 12.
Oh, what do you want to know? The circumstance?
No. So would you be able to disregard that and listen to the evidence and render a fair and impartial verdict in this case? Or would that situation have a bearing on?
No, if I heard the evidence, I'd be able to determine
Okay,
properly.
same question to 16. Would you be able to disregard it or would it
I
play
would
in?
not let it influence.
You would not let it influence you, okay. Juror number 28, would you be able to disregard it or?
I could probably disregard it, but it would still play into my thinking.
Okay, so it would be on the back of your mind while you're listening to the testimony, you wouldn't be able to disregard that. Is that correct?
Like I said, I could probably disregard it, but I would still remember it.
I need to know, you're saying probably, like, would you be able to disregard it, yes or no?
No.
Okay, thank you. Juror number 30, would you be able to disregard it?
No, ma'am.
Thank you. Juror 32, that was no. 50,
No, I wouldn't be able to just.
thank you. 57,
Yes, ma'am, I could disregard.
you would be able to? Okay, thank you. 65,
I would not.
thank you, and 66. You could, or thank you so much. And then is there anyone here that feels that they are not able to sit in judgment of another due to any personal, religious, or moral reason? If that's you, please raise your card. Okay, jurors number 6, 11, 30, 32, 43, and 50. All right, thank you all so much.
I proceed, Judge?
Yes.
Okay, so like the judge told you, the people who end up on the jury are the people we don't hear from. Because what we need to try to get from you is something we can base a decision on about whether or not you should be on the jury. Some people like jury duty. Generally, people that like jury duty, I don't want on the jury. Some people, I guess some people watch TV and they want to do it. But generally, I tell people if you're in the first, I'd say 30 or 40 people, you're kind of in the splash zone. If you've been to SeaWorld and seen Shamu. So it's really important that you let us hear from you. If we're saying something and you have something you want to talk about, raise your hand. I know people don't like talking in front of other people, but it's going to be really important that we kind of determine whether or not you're the right kind of person to be on this jury panel. Like the judge said, not every case is right for everybody. I guess my first question, does anybody have a friend or family member who's been what they consider to be a victim of violent crime? Okay. That's going to be juror number 1, number 2, number 3, number 6, number 9, 15, 16, 18, 20, 22, 23, 24, 25, 30. You get number 20, 32, 36, 42, 48, 49, 50, 51, 52, 53, 57, 61, 62, 64, 65, 66, 67, 68, 70 and 71, 73 through 75. So follow-up question, of those people who raised your cards, who here feels that that incident that happened to your friend, family member, or loved one, who here feels that that would affect your ability to be fair and impartial on a case like this? Okay. So it'd be 2, 3, 6, 22 and 23, 30, 32, 42, 49 and 50. 51, 52, 64, 65, and 73. Okay, so one of the things, I know there are people that have strong, oh yes, number 60.
No, I have a question.
Sure.
Is it okay?
Yeah, of course.
When you say
All
violent.
right, so I'm sorry, I'm gonna need you to stand.
Yeah, if you stand up, man, yeah.
Oh, I'm so
The
sorry.
judge will get mad at me.
No.
Sorry. Does that mean when you say violent, it has to be a person?
Wait, as far as the,
Like a person has to be hurt?
not necessarily a person,
It
no.
could be your parents, like they were robbed and their extended garage was set on fire.
Could be, yeah, whatever you think. I mean, it's in your mind whether or not, I mean, it's hard for me to say that's not something violent if somebody's house was set on
That's why
fire.
I'm asking.
Yeah.
But, okay.
Right. Okay, so anybody else have any similar questions? Yes, ma'am.
Oh, and I'm sorry, if you could state the number for the court report.
64.
When you said a violent crime, is it already they've been convicted or is just that something that happened?
No, that's just something that happened. Yeah, I mean, there are, we all know there's a lot of violent crime. Sometimes it's never convicted or investigated, right? I think that goes a long way towards people's opinion about law enforcement, right? Anybody else have any similar questions? Number 64? Anybody want to ask any questions? Get on the record. Okay. So we have a lot of strong opinions about guns in this country, right? There's argument going back and forth about the Second Amendment right to bear arms. Who here is a strong opponent of the right to bear arms or carry a firearm? That's number 1, number 7, number 18, 22, 35, 41, 49, 50, 45 and 53, 57, 62 through 64, and 73. Yes, ma'am.
Sorry,
Okay.
I do.
Okay. All right. Thank you. Yes.
The right to bear arms is firearms and knives.
Well, I mean, Texas actually, you have constitutional carry for knives and clubs and just about anything you want, but really my question is about firearms. What your opinion about the Second Amendment? Okay, so you're okay with it? Okay. So, yes, number 58.
I'm sorry. Yes, I agree that people should have the right to have a pistol, rifle, or shotgun, AKs and all that kind of stuff. AKs.
Okay, all right. So you're okay with the general concept, you just have some limitations you want to have?
Yes, exactly.
Okay, what about, okay, number 72, yes, ma'am, please go ahead.
Yeah, I just wanted to let the judge know that my granddaughter has arrangements to be picked up from school. I
Okay,
don't know that.
did you get that, Judge?
All right.
72.
Thank you.
Thank you. Okay, of those people who raised their card to that last question, well, no, let me move on to something else. Who here? I know we talk about the right to self-defense, right? And the state talked about that as well. Who here feels that people shouldn't have the right to defend themselves, that everything should be solved by the police? A lot of people think, well, but you know, why don't you just call the police and let them solve it, right? Who here feels that way? Yes, sir, number 51.
I had a question.
Sure.
Who should or should, I couldn't hear what you said. Who should or shouldn't?
What?
You asked that.
About self-defense?
Yeah.
Well, I guess the question is, some people feel that there's really not a right to self-defense, that, you know, you shouldn't, as they call it, take the law into your own hands. Right? That you should, like, if there's a dispute or something like that, it should be resolved by the police and not by people individually. Anybody feel that way? Yes, sir, number 2.
And resolve.
I don't solve the situation. Okay, so I guess the question is, if you're in say you're in a confrontation with somebody, right? Just like kind of hypothetical. And you know, you feel threatened, and so you respond to try to, I guess, either protect yourself or you feel threatened. Some people feel that you shouldn't be allowed to take the law into your own hands. That's how they consider it. You're supposed to let the police resolve the situation. Okay. So wait, so tell me what you say.
Yeah. Well, I live in Windcrest, and that's the greatest, I live there, I've been harassed by people there. And the police have done nothing about it.
Okay.
You know, it was such a piece. California, it's a different process.
Yeah. Yeah, I think a lot of law enforcement officers will tell you that, particularly when they can't help resolve the situation, right?
Having been able to speak there.
Yeah, yeah. We kind of have a hierarchy of law enforcement agencies around here, so. Yes, number 71, yes, sir.
It depends on the circumstance. If the situation is imminent
then yes, you can defend yourself. But if, you know, I tell you something, and then 2 or 3 hours later, you go home and grab your weapon and then come back after me, I think that's wrong. At that point, law enforcement should be informed of that. But if it's imminent, I think you do have the right to defend yourself.
So who decides whether or not it's imminent?
If I put the gun at you right now.
Okay, well, the question is, so is the decision for imminent based upon your opinion or the opinion of the person involved in the situation?
Well, in the circumstances.
Okay, and then you, if you're on the jury, would make a decision whether or not it was actually imminent, right? You said you're a cop, right? Okay, and I guess you look at situations every day and you have to analyze it as you think the law applies, right?
Yes, sir.
Okay, do you think, I know as a peace officer, sometimes it's hard to sit in judgment on other peace officers, right?
Right.
Did you think you could be fair and impartial if you were on this jury?
Okay.
Okay.
I'll go by whatever the evidence has up.
Okay,
And I deal with that every day. I gotta break down whatever happened, look at all the evidence and make my decision.
okay, thank you. Yes, ma'am, number 72.
I live in a part of town that you have to kind of.
You need to speak up a little bit, please.
You have to be alert in the part of town that I live in, and my son has given me a gun and I'm under my bed, it's fully loaded. Anybody comes into the property is trying to break in, feel free to shoot, not the person, but just make a shot.
I would shoot the person, but that's.
Well.
If they're coming in your house, I would just shoot them, yeah.
You're allowed, so, yeah, I would defend myself.
Yeah, okay. Anybody have any comments about either 72 or 71 or any different thoughts you want to raise? Yes, number 20.
I kind of have mixed feelings as well. I mean, you mentioned the whole Will Smith situation, and I think that was excessive. There was no threat on his wife to do that. But if anybody verbally is threatening myself or my children, my family, in my presence without being physical, then I'm making a split decision to defend my family and to remove myself and them from the situation. I don't mean in a knife situation like Jack Dawson or anything like that, but I will take measures into my own hands to separate them, especially if I feel there's an imminent threat in
Yeah,
that moment.
and that's the question, right? So if you're on the jury, and this applies to anybody who's on the jury, you would make a decision based on what you hear about whether or not there was a threat, how imminent it was. Is it mere verbal provocation, or is it something that rises beyond that? Right? We can't tell you the facts of the case. It's all hypothetical. Okay. And that's why Megan talked about, her, not wanting people to be wishy-washy. What we have to do is, nobody's going to judge you for an answer you give. It's actually better if you tell us, no, you're wrong, I don't agree with you, because then that means we have you down one way or the other, and you're either going to be right for this jury or not. And I think a lot of times people are fearful of giving an answer they think people aren't going to like. That's not the case. We just need an answer. Okay. So anybody on the jury would make a decision about whether or not you felt that, the situation justified the force used. That's just a judgment call, right? Anybody here feel like, here's another question I used to ask, but not a whole lot. Who here feels they're not a good judge of people? Like some people feel like they're not. My mom used to get phone calls from solicitors, and I think she had a tendency to believe everybody that called her. And some people feel like they're not a good judge of people. I know we have a lot of teachers. I don't think I've ever seen this many teachers on a jury panel before. Who are the teachers here? Can y'all raise your hands? Number 8. Where do you teach? Okay. Okay. What grade level? 4. Okay. What do you look for to determine whether or not one of your students is lying to you?
I look to see on TV. If I've seen something happen, if I have witnesses, I was call those. Sort of what they saw the enterprise perspective.
Okay, but if they haven't, you talked about it in their response. If they, is there a manner in which somebody responds or gives a statement that would lead you to believe they probably were being truthful, like it's taken a long time for them to formulate an answer, or
file them around that thing?
Getting creative?
Yes, the right kind of thing to say. If they're not sure how to answer, it's for young kid.
Okay. Anybody else, what other teacher wants to share an opinion so we can get you on the record? Number,
Okay.
come on, 24, let's go.
Basically the same thing she said. They like to pause, they look at the floor, they look around the classroom, they just don't want to answer you straightforward. And it's kind of like, okay, then I'm gonna go ask someone else and then they'll try to say it, but they twist the situation around and then it'll finally come out what happened.
Okay, thank you. For us, older people on the jury, you remember back in the 70s, they had this whole thing about body language, right?
Yeah.
Who here thinks they're an expert in body language? Well, you remember that phrase, right? Right? What do you think you would look for in somebody's body language to determine whether or not they're being truthful?
I'm not sure that I would leave that for my determination.
Okay, and what would you look for? And so what number are you?
I'm 59.
59, okay, so what do you think you'd look for?
Twitching, nervousness,
Okay, that's your 60, right?
stand up. Nervousness, twitching, eyes moving around, won't give you eye contact, but just kind of moving around, and you can just kind of tell they're not telling you the truth.
Okay.
That's my opinion.
Okay, anybody else? But yes, number 64.
They're not keeping up with their lives, they're like, they tell you one story and the story gets
Consistency.
right.
Okay. Anybody else have an opinion? Yes, number 55.
What if the person learns how to lie and then they learn what not to do? So then you might think that so they might know what not to do, so they're not gonna do it, so they can get away with the lie.
I don't know, that's down the rabbit hole.
Yeah.
I mean, I'm a big conspiracy theory guy, but that's, I mean, at that point, how would any of us know, right? So it'd be up to me. So what would you look for? I mean, how would you make a determination if somebody was lying?
Then you couldn't, because you wouldn't know if they're lying or not, because they're really good at it. So then how would you know?
I don't know. I guess if you think you couldn't make a determination by how they acted or.
No, because they probably learned from a very good liar, and so they know what. Lying would be something you teach, or you can learn from. You can find someone that's really good at it, and you just follow what they're doing, and then you become good at it.
Or you just take some beta blockers and do the lie detector test. Okay. Yes, number 72.
Going back to body language,
Let's
if
go.
you ask enough questions, the liar is bound to say, there's gonna be a reaction. Yeah.
Okay, anybody else? Yes, number 6.
I also teach a bit.
Okay.
Some kids can just look you right in the eye and lie without a second thought. Some people are just naturally good at it.
Okay.
But again, their stories just don't add up.
Okay.
Even if they're not being shifty.
Yeah, so they can, I get, what you're saying is, they can try to come across as being sincere, but the way the story is being told will indicate that they're not being truthful. No matter how good they are. Is that what you're saying?
Yes.
Anybody have any opinions about what juror number 6 just told us? Anybody else wanna, yes, number 5.
I mean, I think it's also just looking at like the facts. If someone's being consistent verbally, explain as to, let's say, whatever situation happened. But I believe physical cues, if someone's seeming nervous or messing with their hair or their nails or with their shirts, I mean, that person can also have severe anxiety. That person can also have ADHD. ADHD is also inattentive. If someone is looking in the eye, it doesn't mean they're automatically lying. It could just be that that's just how they operate.
Okay, so you'd look for what to make a determination if you thought they were lying?
So if verbally they're explaining to me facts of what's happening, if they can stay consistent, also if it doesn't come across as performative.
Okay.
Right.
Like they're not trying too hard, is that what you mean?
Yes.
Anybody else have any opinions? Yes, number 37.
Yes, I actually teach some of this in classes that I teach. Minors that are actually making more eye contact because they're trying to monitor that combined story. And so the way to gauge that is, especially know baselines of how they behave compared to. There's also.
Yeah, we need to speak louder, please. Yeah, the acoustics are bad in here.
Also distancing language, James Clapper testified before Congress and said that the NSA wasn't spying on America. He said not willingly. That kind of language tends to be a tell or taken into later on. So there's clusters of behavior based on their baseline.
Sounds like you'd be a good juror. I know Megan touched on this, but I wanted to find out, I know we talked about, and she asked questions about the justice system, right? You know, I guess the big issue is, the first thing is, the judge told me we have to make an election for punishment. That's not an indication that there's any admission of wrongdoing. We're required to do that. So we can, because it affects how we do jury selection, okay? Voir dire, as we call it in Texas, and not voir dire, as they call it in Louisiana. But let's talk about what rehabilitation looks like. So who here raised their hands and they said they're supportive of the justice system as being used for rehabilitation. Number 15. Tell me what you mean about rehabilitation.
A little bit with the rehabilitation and aspects of a jail setting programs that they receive different services in order to be able to bring these people back to society in a better place.
Okay, thank you. Number 16, you raised your card too.
Yes, sir.
Tell me what you think.
You know, obviously not every circumstance, but I believe that if people have the desire to change, that they have the ability to change. That sometimes people make mistakes and they don't necessarily need to pay for it for the rest of their lives.
Okay. Anybody else have any opinions? Yes, number 4.
I think, I mean, there is the punishment aspect, but I also do think that not like he said, not to have to pay for a mistake the rest of their lives. They should be able to grow and overcome that.
Okay. Thank you, ma'am. Anybody else have any opinions? Yes, number 65.
I agree with the young man earlier.
Okay. Number 16?
Yes.
Okay.
Same thing.
Okay. Anybody else? Yes, number 34.
I think that they shouldn't have to pay for it for the rest of their life.
Okay.
Show them the way to help themselves what they did.
Okay. Would you agree that, I guess, whether or not it should be used, rehabilitation is kind of on a case-by-case basis, right? Like the judge said, not all cases are the same, right? She gave you the hypothetical about murder, right? How do you feel about that? I mean, would you look at a case-by-case basis to make that decision?
Yes.
Yes.
Okay. Anybody else? Yes, number 63.
Sorry, it's so cold here.
It's always it's about 40 degrees.
Yeah, oh, we're waiting.
Yeah.
I don't think I understood that original question, but I agree it's a case by case. Like, I think some is rehabilitation, some is, I think it said punishment,
Yeah.
some is making amends, just it's really dependent.
Okay.
Case.
And if you're put on the jury, you can make that determination just based upon your
Yes.
judgment.
Yes.
Okay. Okay. All right. So I'm about done. Now, who here has not answered a question or gone on the record? Who wants to be on the jury? Because you're it. I'll tell you a story years ago. I tried a case in county court. We had one juror that made it on there. He didn't answer a single question. We did the whole thing about, hey, if you don't answer questions, he didn't say a word the entire word hour. And then the jury was out deliberating. It was on a DWI case, and this lady showed up. She said, "I'm looking for my son. He has MHMR. He had brain damage, and he snuck out. He got his jury summons, and he snuck out of the house and came down, and he was our juror. And we got a mistrial. So, I mean, that's kind of a special circumstance, but it happens all the time. People, they don't speak, and then they wonder why they ended up on the jury. So that being said, anybody want to say anything? like, put yourself on the record. Number 46, jump on in.
Yeah, I think the question was never asked.
Okay, I do that a lot, my wife says.
Years ago, my brother-in-law pulled a gun on me, pointed it at my face and threatened me.
Like a good brother-in-law.
No, he wasn't. He's not my brother-in-law. And he was scared, and since I've never been as scared, you'd ask questions about friends or family, and it's like, well, no, that's not true, but it's me. And as I've been listening to all these questions, I'm starting to question my ability to be impartial. I want to be, but then I just got this horrible flashback.
Okay, well, let's talk about what Ms. Galloway said. So it's nice that you want to be able to be fair and impartial, right? But maybe this isn't the right kind of jury for you. Would you agree? Okay, and if you still have trauma about that situation that's gonna affect your ability to be fair and impartial, then just say, I can't be fair and impartial in this case.
What's interesting, I didn't think I had trouble until it just started to well up.
Yeah, brothers-in-law will do that to you, won't they? So can we agree this isn't the right case for you?
Yes.
Okay, thank you. Anybody else? Yes, number 62.
Yeah, I just want to go on the record and say that as far as verbal abuse or what warrants physical action, I think racial slurs definitely would warrant Chris Rock slap.
Okay, but you understand the law wouldn't say that, right?
Yeah, so I would, I guess.
Okay, that's fine. Yeah.
Into my hair.
Okay, all right. Yes, number 65.
Also, I've been accused of assault, so I know I will not be fair. I guarantee that.
Okay.
And I did not do it whatsoever.
Well, quick, will you be unfair against the state? Because if so, I may want you.
Probably not.
That's all right. Thank you, sir. I appreciate it. Your number what, 65? Okay. Yes, number 73. So try to speak louder, okay?
Where it's like, this goes back to the question of like, how can you tell someone's why?
All right, so I'm going to pause you for a moment. So the court reporter cannot hear you.
Yeah. Here. Okay.
Robert did cut you out.
The microphone.
The other one? Oh. Oh, like Mr. Microphone.
I know, it's like.
There we go.
Wow.
Karaoke.
Yeah, I'm just touching back on something, in regards to like being able to tell if somebody is lying or not, or if someone is actually guilty and being able to take certain like body language, for example, or like verbal cues. And it was something that number 5 said, where it's, pulling your hair, something it could be due to other conditions, for example, pre-existing conditions like ADHD. And I also kind of like on that same topic, I think I have like the ambiguity perhaps of not being sure if you're, like for example, if you are on autism, like you are high functioning autistic and you don't understand social cues very well, and they're not very obvious to you, like to the other person. I just wanted to pose the possibility, like how difficult that might be for somebody to be able to correctly judge someone if you're guilty or not when you're not. Much. You might just be like, well, they're being accused of it, so it's like guilty, so I cannot.
Okay. Okay. All right, thank you. Anybody else? Last chance. Number 7, jump on in. Number 7.
Judge, with the US government opening, I work for the US Air Force. We have a training sales case, military sales case to a Kuwaiti Air Force. And the defendant resembles the Kuwaiti colonel with whom I'm going to have to meet and discuss the $12 million training case.
All right, so just a moment. Can I have attorney's approach?
With that, he has to deal with a general.
Yeah.
It's like he.
My son and my daughter was State Department. They live in Oman, which is quite divide.
Right.
And
So both sides have agreed that I can tell you, this is not the person you're going to be meeting. All right, thank you.
Okay. Yes, number 6.
In terms of violence.
Yeah, try to speak up, please.
In terms of violence, my grandmother, she was punched in the face by an extended family member. And I don't believe it was brought to court, but this is a person I never want to see ever again in my life. But vice versa.
I'm sorry.
You need to
You're gonna
speak
have
up.
to
speaking too
Yeah,
quickly?
she has to take it down.
Stand up. Speak on the mic.
My grandmother has been the victim of violence and she was hit in the face and she had a nasty black eye for a long time and stuff was stolen by an extended family member. And this is someone I never want to see again. I never want to forgive. But at the same time, while Will Smith, I think that situation is a bit crazy. I think if I was in that situation where somebody was insulting and bullying my girlfriend on a public, in a public area, I would not be able to control myself. So I don't think in certain scenarios in this trial, I could be impartial.
All right, thank you, Judge.
All right, thank you. All right, ladies and gentlemen, I'm gonna have you all step outside and we will bring you back in shortly. No one is excused.
They got their belongings, keep the numbers behind, please.